All right, let me go and grab the book. Give me 1 second, and we're going to jump right into this. Okay, this chapter says moving on. The Titles of Nobility Amendment, 1810 to 1819. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present pension, office, or emolument of any kind whatever for any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. It took almost 9 years, but on 12 March 1819, Virginia became the 13th and final state required to ratify the above amendment to the Constitution for the lowercase United States of America, not to be confused with the much latter look-alike, sound-alike corporate Constitution of the United States of America. The Titles of Nobility Amendment added a strict, specific, and enforceable penalty for violations of the already existing constitutional prohibition in Article 1, Section 9, Clause 8, loss of citizenship and inability to hold public office. So, what are all these district courts and state courts inhabited by Black robe bar member judges and attorneys sporting the title Esquire? They are private courts operated in foreign jurisdictions by undeclared foreign agents. The American Bar Association has a treaty allowing it to function on American soil, which it has grossly abused. What appear to be state statutes are issued under private copyright. Public documents are all public domain and cannot be copyrighted. The take home news for American state citizens is that one, no member of the Bar Association can occupy any public office associated with you, nor your state on the land, nor the continental United States in general. Two, if a Bar Association member is associated with any action pretending or having actual impact upon you or the land jurisdiction of the continental United States, that you or the land jurisdiction, of the continental United States, that action is null and void. Three, none of the courts you commonly see ravaging around issuing charges and handing out orders have jurisdiction over your person or your property. Four, no act of any jurisdiction, no act of any version of Congress or any state legislator tainted by members of the Bar Association can be applied to you. The Bar Association members can work for the federal United States and for the Washington, D.C. municipality and the United Nations city state, and all these foreign governments have created franchises that they operate under your given name. They regularly attack these franchises and make false claims that seem to be addressed to you. A purposeful deceit called personage, but in fact, by maxim of law, those who create franchises are responsible for all debts and upkeep costs of these franchises. Yep, I'm a lawyer, the United Nations American. Maxim of law, we are all responsible for what we create. Note the crimes involved. So let's look at personage. The crime of knowingly misrepresenting a living man or woman as a legal fiction, some form of corporation such as a trust, public utility, or foundation. So anytime you're doing a court case, it should definitely be in there. For example, knowingly mischaracterizing a living woman named Elizabeth Arden as if she were the corporate design company known as Elizabeth Arden Inc. is a crime of personage. Barratry, that's named after the Bar Association for good reason. The crime of knowingly bringing false claims and charges based on personage in order to use foreign statutory law against living people. These two crimes are routinely practiced by members of the bar associations worldwide to inflict unjust punishments, defraud people of property, and to raise money for themselves and the banks they work for. The American Bar Association has violated their corporate charters, the Smith Act, and the Taft-Hartley Act with impunity. Fearing retribution, nobody has had guts enough to take them on and expose their criminality. Now, right here is where a big confusion starts. One, there are living people born on the land of the 50 states united who are civilian inhabitants of the organic states known to be birthright citizens of the continental United States. People are owed all the guarantees of the Constitution, a Republican form of government, a full enjoyment of their natural rights. Two, there are living people who were either born in federal territories or who are defined as federal United States citizens by default, contract, or treaty who operate under the international jurisdiction of the sea as part of a democracy. They have only civil rights which are granted or taken away by members of Congress. Three, there are legal fiction persons, millions of them named after living American state citizens, all routinely called U.S. citizens or United States citizens. We have the actual organic states and we have the states and states that only exist on paper. We have actual people who are citizens or citizens, and we have all sorts of legal fiction entities that are being passed off as capitalized citizens. And you, asleep at the wheel. That means people have to wake up to what's going on. Who is responsible for this mess? It's a long list. The Holy See and the Vatican and all the popes since 1845. The British monarch since 1845. The Crown commercial conglomerate since 1845. The Crown Temple and Bar Association since 1845. The U.S. Army since 1863. The Joint Chiefs of Staff since 1944. The United Nations and the Secretary General since 1944, the United Nations since 1943, the Federal Reserve Association since 1911, the Federal Reserve System since 1913, the World Bank and International Bank of Reconstruction and Development since 1930, international, and 1933, domestic, the International Monetary Fund since 1944, the Vatican Bank since 1930, the Bank of International Settlement since 1944, the United States of America, Inc. since 1868, the United States, Inc. since 1944, the Federal Reserve since 2011, the United States of America, Inc. since 2013, the members of the United States Congress since 1861, the members of the United States Congress since 1933, the Congress of the United States of America since 1868, all presidents since Lincoln except Garfield and Kennedy. Note, legalese cost, huh? Okay, I'll just give me 1 second, you guys. Just tell her the papers on the table to look over. Okay, note, legalese cause the confusion. Only people can be American state citizens. Living people have appellations, not names. Only things have names. Also, living people have autographs. Only corporate officers have signatures. Also, in law, people are either described as, for example, John Quincy of the House Adams, or denoted by the use of all small letters as in John Quincy Adams. This doesn't agree with what you've been taught to think and do and say, but it is of vital importance to know in legal parlance the style in which a name is written tells lawyers what it is. That's huge there. So now let's look at the legal styles. A name written in all capitals, italicized, is the name of a ship. A name written in all small letters represents a living man. John Quincy Adams, lowercase. A name written in all capital letters can only be one of two things: one, a corporation of some kind, or two, a dead man's estate. That is huge. Part I, getting organized. So when you get mail addressed in the form John Quincy Adams, all caps, or John Quincy Adams, first initial, or John Q. Adams, or John Q. Adams, caps, you can rest assured that it is not addressed to any American state citizen, and it is not addressed to the living man, even if that does happen to be your appellation. Darn it all. What's going on with all this misaddressed mail? King George still doesn't know who I am. I don't know what to tell you, John. After all the trouble you've caused, I'd expect him to know it by heart. Must be mail fraud. The Articles of Confederation, the first act, 1781. While most people think that confederation means a loose association of states created for their mutual benefit, there is a darker meaning to the word familiar in criminal law, a collusion of self-interested parties to the detriment of others. And so if you remember when they were trying to go after Trump, he used the word collusion because he said all of them were working together. So if you're trying to file a lawsuit, this is how we bring in RICO on the civil side. We say that everyone colluded together. In that sense, those who sought to create a national government via the Articles of Confederation and those who later created the Constitution for the United States of America were criminals acting against the interests of their home states. Naturally, the organic states possess air, land, and sea jurisdictions. The Articles of Confederation, which created a perpetual union of the states, created an unnatural superstate so that the jurisdictions could be split, with the states retaining the national level jurisdiction on the land, and the new entity, which was to become the federal government, could have control over the international jurisdiction of the sea. The loss of the international jurisdiction was arguably a loss and detriment to the states, especially in that it created two masters, the state on the land and the federal government on the sea, and made the current dilemmas inevitable: land, sea. 1787 to 1789. It's a hot time in old Philadelphia. In the space of only 2 years, two nations and two national trusts were formed. For the American colonies acting under the perfected 1787 Supreme Republican Declaration of the United American Colonies, there was the United States Trust, 1787, and a new nation based on landed estates. This is the land trust owed to the organic states of the United Colonies, which underlies everything else. The actual name of the new nation was and is States of America. Lowercase united, which was just an adjective used to describe their affiliation, but this entity is better known as the continental United States. Next, the United States of America, federal United States, was created and defined by the Constitution of the lowercase United States of America. And the United States Trust, 1789, was set up to receive the assets granted to the federal government. Much later, a third national trust, the Public Charitable Trust, was set up by the corporate United States as a welfare fund to mitigate the suffering of Negroes displaced by the Civil War. This eventually morphed into the Social Security Fund. So do understand, and when they were talking about the states of America, they were simply talking about the states of America being united, lowercase. That's what that means. The United States of America. And so that's how it began to morph into all of these different names. And so you have to know what they're talking about and when they were talking about it. So according to the 1829 Webster's Dictionary, the word federal was a synonym for contract at that time. So federal government meant contract government. All constitutions are contracts involving debt. In this case, the debt of the American states incurred as a result of creating the federal government and agreeing to pay for the services it provided. The condo association. Think of it like a condo association. Each of the estates had their own land and sovereignty, yet they were all condo association members. Alaska State, New York State, Georgia State, federal government, federal workers. There were certain tasks they either couldn't or didn't want to do for themselves, like raking leaves and mowing lawns, snow removal in the winter, security all year long, garbage pickup, appliance maintenance, and so on. So they hired these 19 enumerated powers out to the federal government. At the time, the Americans had no navy, only a commercial fleet that was easy prey on the high seas. The British had the best navy in the world and a desperate need for American raw materials. It was natural to strike a deal allowing the British to manage the jurisdiction of the sea and provide protection for American shipping. They made several treaties promising perpetual aid, friendship, and amity for the Americans, guaranteed by the British on the high seas and inland waterways. In addition to the lowercase United States of America and the separate foreign entity operating the jurisdiction of the sea as the United States of America, there was a third party on the stage. 1790 Follies. The United States, a foreign for-profit investment company, which under the leadership of its president, George Washington, is about to start supplying 19 enumerated services to the American states under an equity contract known as, drumroll, the Constitution for the United States of America. So when you understand the constitutions, they are actual contracts for their employees. The office of the president. The office of the president is and has always been a company office and later a corporate office, not a head of state. This is because the separate states are each sovereign nations acting for international purposes as a federation. The Ohio state is part of the Confederation of the lowercase United States of America, aka continental United States, in the same way as Bulgaria was part of the old Soviet Union. There are actually three presidential offices: President of the lowercase United States of America, major on the land, President of the United States of America, which is the minor on the sea, and President of the United States, which is the municipal. This is how Abraham Lincoln and Barack Obama, both of whom are ineligible to serve as president of the lowercase United States of America major, are nonetheless able to serve as president of the United States of minor and as president of the United States municipal. Here's the actual definition of president from the 1856 version of a law dictionary adapted to the Constitution and laws of the United States by John Bouvier. President, an officer of a company who is to direct the manner in which business is to be transacted. From the decision of the president, there is an appeal to the body over which he presides. Today, we will recognize this office as the Chief Executive Officer. The actual Constitution creating the federal United States and delegating the international jurisdiction of the sea to it names the president commander-in-chief of the armed forces because he is responsible for defending the states from attack by foreign countries and may also be called upon to settle disputes between states over a variety of federally controlled issues, including interstate commerce. Commerce is business conducted between corporations, including the federal states of the states, like the state of Ohio and the state of Indiana. Corporations accrue income, hence the income tax. Trade is business conducted between people, associations, sole proprietors, simple partnerships, pure trust, and other unincorporated business structures. These entities accrue private property, not income. The president, number one, the president's duty under the actual constitution pertaining to the continental United States have never changed. His job is to determine how, not what, when, how much, where, at what cost, or why business is conducted. That is the business of the members of Congress when and if they act as deputies, accounting the fiduciary officers of their home states, like the Ohio state and the Wisconsin state, and convene a continental Congress. The president's job with respect to actual states on the land is purely executive. He figures out how to do what the state deputies tell him to do. And the state deputies are directly accountable to the people, the House of Representatives, and to the actual state legislature, which is the Senate. Please note that the Ohio state legislature, the continental state, is not the same as the state of Ohio legislature, which is the federal state. President number two, the president's duties under the similar name Constitution of the United States of America pertain solely to the affairs of the federal states that operate in the international jurisdiction of the sea, including the states of states like the state of Ohio or the all-cap state of Ohio, or most recently Ohio and their franchises. He has more power in this role, but is still limited in that the federal Congress acts as his board of directors, holds the purse strings on the federal budget, and so on. It is in this capacity that he introduces lobbies for or vetoes federal legislation. This is all in-house and only impacts federal states or states, like the state of Ohio, other federal corporations, federal territories, and United States citizens. President number three, as President of the United States, a corporate CEO acting under the Constitution of the United States, know of America about it. He has been given dictatorial style power and can run federal functions by executive orders issued to federal municipal franchises incorporated under the laws of the Washington, D.C. municipality, an independent international city-state. The Washington, D.C. municipality has no actual authority outside of the physical boundaries of Washington, D.C. with respect to the continental United States. Despite gross pretensions otherwise, and the president acting in this role has only the powers of any other corporate CEO. The Washington, D.C. municipal government has created hundreds of millions of citizens for itself, named after living Americans and American cities and towns. The claims to own and operate all of these franchises as chattel property. These are all United States citizens, debt slaves, which exist only on paper, but which are used as devices to promote fraud against actual people, actual towns, counties, and cities. So, what is the Constitution? It is a two-part equity contract consisting of a trust indenture, preamble, and a Bill of Rights, and a services agreement contract. It obligates the United States commercial company to provide certain enumerated services, including protection of the national trust, and the subscribing states agreed to pay for all of this. No wonder United States citizens are so eager to defend the Constitution from all enemies, foreign and domestic. It's their meal ticket. American state citizens have a different view of it, that of increasingly disgusted consumers. Okay, so I'm going to stop. I'm going to stop at page 78, and then everybody can pick up there. So I'm going to stop at 78. Okay, so I'm going to leave the third phase of the Constitution. As a document, the Constitution for the United States of America is straightforward, a trust indenture and a services contract, but there is another aspect to it that is a matter of function rather than form. The Constitution, the real one, is a trilateral international treaty. It binds each state to the federal union. It binds each state to the other states. It binds the state as a group to the federal union. Another important point to note is that all parties are acting in international commerce. Each state of America is, for the purpose of international law, a separate nation. So the Constitution represents a solemn treaty among many nations, obligating each to provide services or sustenance or both for the others, all of them in interconnected according to the terms of the agreements reached. Other important facts to know, not all of the original 13 colonies signed on to the Constitution. Only 9 originally ratified it. The rest joined the Union at a later time. And new states were added under the Northwest Ordinance and the Equal Footing Doctrine for almost 100 years, right up until the Civil War. With the Civil War, the country entered a crisis that is still not resolved. As a result, no true American states known as states of America have been added to the federal union since 1860. All the states which exist in the western half of the United States of America are not really states of America. Under the Northwest Ordinance, because there has been no competent Congress convened since 1860 that is able to grant them such status. Instead, these states have been operated entirely as federal states and treated more or less like real states of America under separate compacts or trusts that agreed to honor their incipient land jurisdiction as if they were true states on the land. Please note that the people are not direct parties to the Constitution and are only second-hand and subrogated standing. The states and the federal union are the direct parties obligated by the contract. Also notice that the Constitution is not the source of any of your rights and material interests. Instead, it restricts the federal union and limits it and provides guarantees protecting rights and prerogatives living people already have. So pick a constitution, any constitution, step right up. Today's constitution is 3 for $5. One, the original equity contract known as the Constitution for the lowercase United States of America, which created the federal United States, is built on articles of treaty. Amendments or slight changes are interpretations of the treaty made by agreement of the subscribing parties. There are 10 articles and 3 amendments to the original equity contract, including one known as the Titles of Nobility, Amendment Tona, which does not appear in the corporate constitution published by the United States of America, incorporated circa 1868. Tona made it explicitly impossible for members of the Bar Association to hold any public office because they were in receipt of a foreign title of nobility, which is called an esquire. Amendments to the original equity contract require a properly seated Congress composed of deputies representing the land, each states, and a lengthy ratification process by each state legislator operating in traditional capacity as state delegates, deputies. Hold on, let me mute you guys. All right. Because neither the Congress nor the state legislators have been operating in their proper capacity, no amendments have been made to the actual Constitution since 1860. This is the actual Constitution that establishes law of the land, that is the law that the federal government must operate under with respect to the land jurisdiction and the people of the land. We are owed all of our natural rights and a Republican form of government, too. The corporate constitution, known as the Constitution of this United States of America, is built of articles of incorporation, a different kind of articles entirely. Amendments to this Constitution do not strictly require any ratification by the federal state franchises, and they only represent changes in public policy by the corporation, not any amendment of the actual Constitution creating the federal United States. This means that the 13th Amendment onward are not public law, only private law affecting the officers and employees of the United States of America, Inc. The existence of this corporate constitution is a direct result of the fact that the federal United States is a separate and, with respect to us, foreign nation. It is allowed to organize its internal affairs as it sees fit and to impose whatever laws it wishes to apply to its citizens within its international territorial jurisdiction. This is why the entire federal code, including the Internal Revenue Code, persists in calling birthright citizens of the continental United States non-resident alien. And it says, I am a non-resident alien. Okay, so I'm going to stop here because as you can see, it gets really, really good. as you go deeper in this and understanding, who you are, understanding about the state of states, the Constitution versus a Constitution. There's all of these. Well, you know what? Let me go ahead and just read that, and then that'll take us right up to 6. Let me just go back and read this. From the perspective of the federal United States, we are aliens when we enter their international jurisdictions, and we are either resident or non-resident in their federal states. The municipal constitution is known as the Constitution of the United States. By now, you are shaking your head and thinking, which United States? Continental, federal, corporate? The short answer is corporate, just another form of corporate. This is the Constitution of the Washington, D.C. municipality, an independent international city-state run as the oligarchy by the members of Congress. It is an offshoot of the federal United States, which granted it a treaty similar to the treaty that the United Colonies granted to the continental United States, in which they granted in turn to the federal United States. Think of it like a set of nesting dolls. The Global Estate Trust chartered the United Colonies, which chartered the continental states, which chartered the federal states, which chartered the municipal city-state. The municipal constitution is simpler than the federal United States corporate constitution and is loosely based on it. The citizens of the Washington, D.C. municipality and its franchisor are all debt slaves, including the state of Ohio and capitalized John Quincy Adams, interlocking trust directorates. Air, land, sea, it's just a mess. Then the state of states. In addition to all these federal constitutions, there are also state level constitutions. There are the original state constitutions, which are treaties there are the federal state constitutions, which are corporate charters, and there are the federal state municipal constitutions, which are corporate municipal charters. The Ohio state is one of the continental United States operating on the land jurisdiction of the United Colonies. It's a republic. The state of Ohio is a corporate franchise of the federal United States operating in the sea jurisdiction of the United Colonies. It's a constitutional democracy. And the all-cap state of Ohio is a corporate franchise of the Washington, D.C. municipality, which is operating as an independent international city-state. It's an oligarchy operated by Congress. And just recently, the United Nations, Inc. bought all of the DC municipal franchises and is in the process of renaming them so that the state of Ohio will be operated by the United Nations as Ohio. And the all caps John Quincy Adams Estate Trust will be operated as a public transmitting utility under the name John Q. Adams. So look for the FARC coming to your mailbox soon. The Constitution versus a Constitution. Obviously, with all of these semantic deceit flying from the fan, it is nearly impossible to carry on a sane conversation. Which United States are you talking about? Which state are you referring to? Which Constitution? Which citizen? These are only one original equity contract tying any of the continental United States to the federal United States. And it is doubtful that the entities currently representing the federal United States have any standing to trade upon that contract. As we shall see, the federal United States has been repeatedly bankrupt by British and European interests, and various ploys have been used by those same interests to fraudulently entrap the assets of the continental United States in these bankruptcies. Our point, there's a reason for the use of all these deceptively similar names. They have been used to promote fraud on a vast scale. And that takes us to part 6, the Civil War. All right, you guys. Any comments, questions, thoughts on this as we close out?
It explains a lot. It explains a lot.
Yes, it does. It explains a lot. And again, you can take the same information and pull it into a court case, and they will have to answer all of those questions. Who are you? Just that simple.
Which United States are you talking about?
Mm-hmm. No, and who are you talking to?
And who are you talking to?
Right. All right. Well, listen, let's close it out for the evening. And this will have this it'll be recorded, it'll be in our school. And then we come back, we'll start with part 6 next month, okay?
Dr. Sherry, you're much appreciated. And shout
Oh,
out to you, Shiloh.
good evening, everybody. Thank you so much. Bye-bye.